Good afternoon. My name is Patrick Cummings. I'm counsel with NYSAC. I want to thank the over 120 county leaders that are on this webinar. What's happened over the past 2 weeks has been nothing short of amazing. And I say amazing because that's been the response I've seen and NYSAC has seen from counties. It's just that, it's been amazing. Our entire way of life, our entire way of governing, providing services, it's been flipped upside down. But we've met that challenge. We're fighting this fight against this virus all together. It's been information gathering, sharing, everybody pulling together, using resources. On these nightly calls, we really appreciate you dialing in with Steve at 7 o'clock every night, keeping us up to date, you telling us what's happening in the field. We're all teaching each other. And a lot of it's been, we're learning as we go. These are all new rules and figuring out how to go through these waters together. I want to remind everybody on those calls and at any time, keep your questions and your suggestions coming into us at coronavirus@nysac.org. We're taking these, we're sending these multiple places. We're first and foremost sending these questions, suggestions straight to the second floor. We're trying to, and we have seen influences on executive orders that have helped in the field based on your suggestions. We're getting answers back, some of these questions from the second floor. We're also using our county attorneys in the field to help with some of these. So together, we're all figuring this out together. And that's what we're doing together as public officials and leaders. But the private sector is playing a huge role in this as well. And that is what I want to, why we're having this webinar today. Bill Lowe and Karlee Bolaños of Bolaños Lowe reached out to us and said, you know, we'd really like to help with what we know what's going on in they specialize in New York municipal labor law in the private sector. They already work with a lot of counties and towns, and they want to share this information. We are so appreciative of this. We're going to be seeing more and more of this with the private sector stepping up, helping us out, support the counties in this fight. Tonight, IBM is going to be joining Steve with this call with ideas on how they can help. So we're seeing more and more in this, and I think we're going to keep this going in the series until we win this fight, which we will. This is going to be a webinar based on labor law best practices with the COVID issue. We've been hearing more and more counties with questions on this because we want to, yes, we want to win this fight, but we want to make sure we're doing it in the right way in protecting our own employees. And so we got to, when doing this and we're sending our employees out in the field or even sending them home as non-essentials, we got to know what we can and can't do with those employees and what the laws of the land require. And this is why I want to thank again Bill and Karlee, and they're going to start up with this webinar now. The format's going to be, they're going to be in lecture mode and go through the slides that you'll be able to follow along with. This will be recorded, and we'll send you the slides so you can share these with your other county leaders that weren't able to make this call. Karlee and Bill will be available for your questions and answers on this. You can type them in, and we'll do what we can in the hour that we're together to answer. If you have any other questions, send them to us. We'll work with them and get them back to you with the answers. So without further delay, it is my pleasure to introduce Bill and Karlee of Lowe and Bolaños. Karlee?
Thank you so much, Patrick, for all your kind words. And Bill and I would just like to say thank you to all of you public servants on the call. It truly has been amazing to watch everything that you're doing and how hard you're working. So this is just a tiny bit that Bill and I figured we could help you with and present you with information regarding the new laws. We do have an agenda for you today. On the next slide, we're going to cover the New York State executive orders just very briefly as they relate to labor and employment, and just a moment on the guidance that's been published regarding the executive orders. We're going to spend a few minutes in the beginning talking about other applicable laws. By that, I mean non-COVID type laws. And then we're going to move right into the New York State and federal coronavirus paid sick leave legislation, which you've heard about. So a primary goal here is for us to teach you the nuts and bolts, at least the basics on those 3 new pieces of legislation, including the Emergency Family and Medical Leave Act. So we'll walk you through those new laws so that you have a basic understanding of what those laws entail. And then we are going to just very briefly mention unemployment and tax credits. However, we're not spending any time on that and have removed the majority of those slides because for county purposes, the tax credits that you've been hearing about in order to sort of recoup some of the monies that you'll pay with respect to the new federal statute are not going to be available for counties. And then we're going to spend probably most of the presentation talking, or at least a good chunk of it, talking about the labor and employment law hot issues that a lot of you have been experiencing. Okay. So as you all know, it all started with Executive Order 202. The governor issued the disaster emergency, and then we moved into a series of executive orders. On the next slide, you'll see that the important executive order for purposes of counties is the 202.4. So this was the moment when the local governments had to reduce the non-essential personnel had to be, at the 50% or lower threshold. And so we began rapidly sorting out who were the essentials, non-essentials, getting those non-essential folks able to work from their homes. And that's what we're experiencing today. So this is still the applicable executive order for government. There has been some question regarding, well, what about Executive Order 202.8 and the guidance that has been issued? Well, the frequently asked questions regarding the executive orders, question number 5, which was published earlier this week, clarified that Executive Order 202.4 is still the pertinent executive order in terms of essential, non-essential, and the percentage of workers that have to be working from home for government. So on the next slide, we did include a brief overview of 202.8. You're all familiar with this, but again, 202.4 is clearly the pertinent executive order for your staffing purposes as municipalities. And the 202.8, though, is useful in terms of the guidance lists the types of essential services. So if you are experiencing any difficulty, I know some of the transportation departments have been trying to get a handle on what's essential, what's not essential. Is planting sod essential, not essential? Are these types of builds that we're working on essential, non-essential? The Executive Order 202 and the clarifying guidance can be helpful for municipalities in sorting out what is essential and what is not essential services. So we included it here for those purposes. On the next slide, I provide a link to our website. We did a detailed summary of all of the guidance relating to essential and non-essential businesses. This can be a good reference for you or maybe some private sector businesses in your community that are struggling with this issue and asking you questions about that. So we did provide that link there. Next slide. And so those notable points, I think, are important to keep in mind. One of the notable points is that you've probably heard about this designation form that businesses may use to determine whether or not their business is essential. This is something that some of you are posting up on your COVID response web pages for local businesses to be able to use to determine whether or not they are essential businesses. If they're having any struggle with that, they shouldn't be hesitating to use this form. But I did want to mention that since municipalities are covered by 202.4, not 202.8, this is not a form that municipalities should be using themselves for their essential, non-essential clarifications, but rather for people, businesses in your community to assist with that determination. Next slide. So that was just a very brief overview of the executive orders as they relate to counties. We just wanted to point out that frequently asked question number 5, 202.4 is your operative essential, non-essential plan. But now we want to move into covering other applicable laws. Bill and I are going to spend the next few minutes talking about paid sick leave under the New York State COVID-19 emergency legislation, the emergency FMLA expansion, and the emergency paid sick leave law. So we will review those laws, but before we got into that, I did just want to mention a few laws that still exist, we can't forget about as we work through the COVID-19 emergency, and those are primarily FMLA, ADA, and the human rights law, unemployment. Those are the big laws. So first and foremost, FMLA. We have seen an uptick in claims from individuals expressing that they're having mental health issues. There are people with existing anxiety conditions are having major flare-ups of those conditions, and other individuals that have mental health illnesses are really coming forward with your basic FMLA type requests, or people coming forward with ordinary ADA type requests regarding their work at home situations and whether or not accommodations are being followed in those situations with workers working at home. And certainly if individuals are presenting with underlying health conditions and they feel concern about those underlying health conditions, and possibly their physicians or providers feel concern about those underlying health conditions, we are seeing that employees are coming forward with notices from their doctors, requesting accommodations or requesting time off because of their underlying health condition, not because they have acute symptoms of the coronavirus or anything like that, but that their underlying health conditions are causing concern for their physicians. So they're coming forward with ordinary disability notes, and we have to remember that we still need to continue to process any type of disability claims, requests for accommodations in line with our existing policies, the Americans with Disabilities Act and the New York State Human Rights Law. So those are important laws to keep in mind. And of course, New York State unemployment is changing a bit. Waiting periods are being waived. Employees are experiencing great difficulty getting into line in order to apply for their benefits. The websites are crashing, things of that nature, but all of those unemployment rules continue to apply. We see that much more in the private sector right now than we do in the public. I did just want to mention important, and we'll get into this towards the end of the presentation. Now is a time when your human resources department becomes extremely important. At this point already, they should have gone through your local employee handbook, your policies, any codes that you may have, and certainly any applicable CBAs, and have pulled for county law departments any rules within those CBAs or within those handbooks or policy manuals that could possibly be implicated during emergency. Sometimes your collective bargaining agreements have provisions regarding emergencies and states of emergencies, pay that might be required, different types of notices that might be required, different types of rules that apply if people's jobs are changing or shifting. These rules can also be contained in employee handbooks. So really, now, if it hasn't happened already, I would request that your Human Resources Department provide legal with an overview of the different types of rules, policies, and procedures that they administer through Human Resources and through the collective bargaining agreements that you may have in place that could somehow relate to this COVID-19 emergency that we're experiencing. I know there's a lot of rules within CBAs and handbooks that touch upon if business is closed, including if a section of the business is closed. There's definitely leave of absence language probably in both your employee handbook and in terms of your collective bargaining agreements or any separately negotiated attendance policies. So those are all important to keep in mind and things that you should have available to you now as you make decisions. Next slide. Yep, thanks. So now we're going to move into education regarding first the New York State coronavirus legislation, and then we'll talk about the federal coronavirus legislation. So the New York law was signed into law by the Cuomo on March 18th. It applies to both public and private employers. The essence of this law was that you must now provide paid sick leave and job protection, I'll explain that in a moment, to employees who have been subject to a quarantine. And that is defined as, quarantine is defined as a mandatory or precautionary order that's issued by a government entity. So it's the New York State or the local health board or the any other government entity that might or possibly issue a quarantine or isolation notice. So for the New York legislation, it's a very particular type of issue that would cause the need for the leave. As we get into the federal, it's more expansive. There's going to be 6 reasons why a person might be on leave. But for the New York benefit, it has to do with an employee who's quarantined. And I should mention that the definition of employee is a little bit more expansive than just an employee. It also applies to a child of an employee. So if an employee's child is subject to a quarantine or isolation order, same government issued, then also this leave would apply to the employee. So it's a specific purpose, this New York coronavirus legislation. It's not an expansive type of benefit, although certainly some individuals are going to have a need for this type of leave, and this will have to be administered. Hopefully by now, your Human Resources Department, hopefully in conjunction with your department in law, have developed a policy for the administration of the New York coronavirus paid leave. It's important that you have that in place. The law requires notice to the employee, and the frequently asked questions that were recently posted on the New York COVID web pages indicate that employees should be notified of these benefits. And certainly at this point in time, department heads should understand this new benefit and should have some type of guidance from either your department or Human Resources explaining how this benefit is to be administered, what qualifies, particularly because the New York benefit is very specific to the quarantine type situation. One thing I do want to mention, most of you have not experienced New York paid family leave in general at this point in time because public employers did not have to opt into providing that benefit. But this is part of the New York State paid family leave, so private sector employers have more experience with insurance around this. You might be hearing bits and pieces about it's only 5 days. Here, public employers have to provide 14 days of paid sick leave. There are separate rules for different types of employers where only 5 days of paid leave have to be provided, and that disability, the paid family leave insurance policies can be drawn from. But the rules are different for public. So we're just teaching you about those public rules. For public, it's going to be 14 days of paid sick leave, job protected, meaning that the employee has to be able to return to their exact same job with their same benefits, with no changes to their terms and conditions of employment if they do have to go out on this 14-day quarantine leave. And again, I mentioned it's the employee or the employee's child. It's quite specific. Next slide, please. So we've got the 14 days job protected leave. That's the gist of this benefit. I just want to take a moment to explain that 14-day a little bit. So it is calendar days that the benefit covers. However, New York has recently clarified this because there were a lot of questions about the 14 days. The best way to look at it is that it's a 2-week period, and the benefit is available to employees, full-time or part-time, based on what they regularly would have worked in that 2-week period. So if an employee would regularly have been a 70-hour employee or a 75-hour employee, that is what the pay should be based on for this 14-day paid leave period. If they're 80 hours, it's 80 hours. So it's looking at a 2-week snapshot and what would a person normally have been paid during that time period. That's how you administer this benefit. Okay, next slide, please. There's already application forms ready. Again, private sector is more used to these forms for New York State paid family leave, but there's special forms that both the private and the public sector are now required to use for these benefits. These applications should be ready and available to employees. I really like them attached, affixed to that policy that you've created regarding this benefit that educates employees about the benefit and includes the application forms. At a minimum, as I said, that some type of guidance should be going to your department heads from either Human Resources, County Executive Office, or Law Department regarding this, and you could attach as a packet the forms to use so that people know what to do if an employee requests this type of leave or needs this type of leave. So there's two, this is just a picture of one of the forms. This is what it looks like. It's about a 4-page document. There's 2 separate forms. One is if an employee is quarantined. The other is if the child of the employee is quarantined. So there's a separate process that has to be followed. And Bill and I have shared with you here the links to be able to get those forms. And we can also send to NYSAC after this actual copies of PDFs of the forms too, so that you can have those available. Next slide. So I'm going to wrap up this New York law. I just want to go over a couple slides here with some additional considerations. Important to note, this benefit, the 14-day leave, has to be provided without any loss of accruals. Before this law was published, I know a lot of municipalities were developing their own policies to assist employees, and you may have said that employees will draw upon their accruals. That is not the case since this law was effective when it was passed. So if somebody is quarantined or their child is quarantined, you have to go back to that date and provide back any of their accruals if they used, if you required them to use the accruals. So this is in addition to whatever county provided sick leave benefit you've been providing to employees. There's also a provision in this law that prohibits discrimination or retaliation against employees for taking the leave, and that can include, for example, a quarantined person coming back to work and people not wanting to be around them, not including them in meetings, things of that nature. So there is a separate specific discrimination and retaliation prohibition built into the New York law. And as I mentioned, it's job protected leave. Next slide. So employees, if employees are able to work from home while quarantined, so let's say it's a non-essential person that you have set up at home, they would not qualify for this benefit. So these are people that are not able to work from home. And the only caution I have there is provided that the employee is actually not ill, because an employee may be quarantined and not have any illness, or an employee may be quarantined and very ill. So you can't require somebody to work who is very ill with COVID-19. This legislation does not infringe, diminish, or impair CBA rights. Certainly, if something in your CBA would somehow prohibit this 14 days from being provided, this legislation would supersede the CBA. But to the extent you feel that you can apply a CBA rule instead of this provision, that would not be accurate unless for some reason it mirrors the benefit and is more than the benefit provides. In that case, we can always provide more in the CBAs than the law provides for. That's true for civil service, it's true for any of our laws, but not take away a benefit that's otherwise provided by the state. And then we're going to move next into the federal leave. This benefit is in addition to the federal leave, but they run concurrently. I'm going to turn it over to Bill Lowe to talk about the next few slides, the federal legislation.
All right, thank you, Karlee. So now, in turning to the federal legislation, it's important just to remember that the final bill that passed had some significant changes from what originally passed the House. So it moved pretty kind of quickly towards the end there. So if you didn't follow the process that closely, there may be some updates here as I go through the legislation on some of the items that changed in the final bill. So the legislation is titled the Families First Coronavirus Response Act. It was passed by the Senate and signed by the President on March 18th. And it becomes effective on April 1st, not immediately like the New York State legislation Karlee just talked about. And its provisions will all expire on December 31st, 2020. So these aren't kind of ongoing expansions of the law or additions to the law. These do have an end date to them. One note here is the effective date was recently clarified through DOL guidance that was issued on Tuesday of this week. Originally, it was understood that it took effect on April 2nd, but it looked like they tried to just have it be starting on the beginning of the quarter, so they revised that to April 1st. The link here on this slide is an important one. This is a link to the USDOL's Wage and Hour Division's COVID-19 page, and it has a handful of really helpful resources. They have fact sheets for both employees and employers, Q&As on a series of topics that are relevant to the issue, and I mention those in particular because I anticipate that the DOL will continue to update those as additional questions from stakeholders come in, so something to kind of keep an eye on. And also the employee rights poster is available here. So this was made available yesterday. It needs to be posted on premises. The guidance also says this can be, this requirement can be satisfied by emailing or directly mailing the form to employees or posting it on an internal website that you may have. But the legislation has, again, 4 key components. You have Emergency Paid Sick Leave Act, the Emergency Family and Medical Leave Expansion Act, and then Emergency Unemployment Insurance Stabilization and Access Act, and the tax credits for the emergency paid sick leave and the emergency FMLA. And we're really going to focus just on those first 2. So you go to the next slide, please. So first we'll talk about the Emergency Paid Sick Leave Act. So which employers are covered by this? This applies to, again, private employers with fewer than 500 employees, and then public employers. And what does this act require? Well, it requires covered employers to provide 80 hours of paid sick leave to employees who are unable to work or telework for reasons related to COVID-19. And a note on part-time employees, their entitlement is going to be based on their average number of hours worked in a 2-week period. And if an employee's normal hours are unknown or they vary, you can use a 6-month average to determine the appropriate amount of daily leave for that 2-week period. Next slide, please. So the circumstances in which an employee is eligible for paid sick leave. Employees will be eligible in 6 separate circumstances. First, if they're subject to a government quarantine or isolation order related to COVID-19. If they are advised by a healthcare provider to self-quarantine due to COVID-19 concerns. If they are experiencing symptoms of COVID-19 and are in the process of seeking a medical diagnosis. If they are caring for an individual subject to a quarantine or isolation order or advised by a healthcare provider to self-quarantine due to COVID-19 concerns. If they are caring for the employee's child, if the child's school or daycare is closed or unavailable due to the public health emergency. And then finally, the last one is basically a catch-all. It's if they're experiencing any other substantially similar condition. So again, those are the 6 types of scenarios in which an individual is going to be eligible for emergency paid sick leave under the federal legislation. So again, a little broader scope than the New York version that Karlee just talked about. Next slide, please. So assuming an employee is going to be eligible for federal emergency paid sick leave, how much are they able to collect under the law? So first, think about those first 3 scenarios from the last slide, where the employee is unable to work or telework for a personal COVID-19 related reason. So in these circumstances, employees are entitled to 80 hours of paid sick leave at their regular rate of pay. They've put some caps on this, so this would be capped at $511 per day and up to $5,110 in total. And then so for employees who qualify under the next 3 scenarios, 4 through 6 from the prior slide, the employee is going to be entitled to up to 80 hours of paid sick leave at 2/3 of his or her regular rate of pay. Again, this has caps. It's capped at $200 per day and then up to $2,000 in the aggregate. And the next slide just lays out a couple important additional considerations regarding the federal version of this emergency paid sick leave. So first, all employees, regardless of their length of employment, are eligible for this paid leave. The only individuals who will be exempted are healthcare providers and emergency responders. That's the only exemption that's in the law. Second, this 80-hour emergency paid sick leave allotment does not carry over to 2021. So it needs to be utilized in the calendar year 2020 if it will be utilized at all. Next, the leave provided under this law must be provided to employees in addition to the employee's existing leave offerings. So again, this benefit is on top of any existing benefits you may have in policies, procedures, or in collective bargaining agreements. And then finally, employers cannot force employees to use other paid leave before utilizing emergency paid sick leave. And this is similar to the point Karlee raised in the New York legislation as well. And if you go to the next slide, this contains just a few potential scenarios that I think are worth discussing and kind of thinking about as you're dealing with issues as they come up with your workforce. So the first is, say an employee is home from work and subject to a mandatory order of quarantine issued by New York State. So this person will be covered under both the federal Emergency Paid Sick Leave Act and the New York Paid Sick Leave legislation. And so based on the recent guidance from New York that Karlee mentioned in those FAQs, the federal leave would run first. And unless that employee is scheduled to work more than 80 hours in a 14-day period under normal circumstances, the individual would not be entitled to any additional leave under the New York Paid Sick Leave bill. So then the second scenario here is an employee is home caring for a family member who is subject to a mandatory order of isolation issued by a county. This employee would be covered under federal emergency paid sick leave. So they would be entitled to 80 hours of paid sick leave at 2/3 of his or her regular rate. And potentially they would also be covered under the expansions to the New York paid family leave that Karlee mentioned previously. Next, what if just an employee is home caring for a child with a stomach bug? So if that ailment is not related to COVID-19, this would likely only be covered by, again, any normal sick leave policies or practices or provisions that are contained in your relevant collective bargaining agreement. And then the last one, so an employee is not willing to come to work because of COVID-19 and is not in a position where they may telework. This is one that I really think is important to consider now. We expect this to come up frequently. We've seen this already with a lot of employers dealing with employees who are just kind of raising this, that they don't want to come in because of just general concerns. And in these situations, this will generally only be covered by normal paid time off policies. So it may not be allowable depending on the employee's given rationale or what is in your existing policies or practices. So kind of piggybacking on Karlee's comments, I think this is one where, again, it's really important to be internally reviewing your existing benefit policies, practices, and anything relevant in your collective bargaining agreements so that you understand if it's not impacted by some of this new federal or state legislation, how would we handle this type of issue under normal circumstances? Okay, so then moving to the Emergency Family Medical Leave Expansion Act. This is one area of the legislation that was really drastically modified in the final version of the bill. So who's covered by it? Again, this applies to private employers with fewer than 500 employees and public employers. So it's the same as the other federal provision. As far as eligibility for employees, any employee who has worked for at least 30 days before the designated leave may be eligible. So unlike the other federal piece here, this does have a 30-day work requirement for eligibility. And then what are the benefits under this expansion of the FMLA? So covered employers must provide up to 12 weeks of job protected leave to employees who are unable to work or telework in order to care for a child if the child's school or child care is closed or unavailable because of a public health emergency. And again, this is much more limited in scope than the other forms of leave we've discussed, and it's also much more limited in scope than what it was originally proposed to be in the first version of the legislation. Okay, so if we move to the next slide. So what are eligible employees entitled to under this expansion? So the first 10 days of the leave may be unpaid, but employees are able to substitute any accrued paid leave during this period, but an employer cannot require this. And also, there's a scenario where they would apply for both the emergency family medical leave and the emergency paid sick leave at the same time. And in that case, they could avail themselves of the emergency paid sick leave for the first 10 days and then switch to the emergency FMLA for the remainder. So then following the first 10 days, though, full-time employees will receive compensation at 2/3 of their regular rate of pay. Again, this similarly has a cap on payments, and those are at $200 per day and $10,000 in the aggregate. And then what about exemptions? So again, as is the case with emergency paid sick leave, healthcare providers and emergency responders are not covered by this. And there's also a carve out for small businesses with fewer than 50 employees. They may be exempt based on a demonstration that the leave would jeopardize their viability. And we'll wrap up our discussion of the federal legislation on the next slide here by talking about the tax credit. And I just want to briefly mention this component because it's been kind of a source of some confusion. But unfortunately, the most important thing here is that these tax credits, which otherwise would cover 100% of paid sick leave and emergency FMLA wages that are paid, will not apply to public employers. Further guidance from the IRS is expected to be issued in the coming days. I would keep an eye out for that, but I don't anticipate this will be expanded. That would require a change in the law, which, who knows, it may come. But at least as of now, this is going to not apply to public employers. And so again, that wraps kind of our brief overview of the federal legislation. I'm going to turn it back to Karlee now to go over a couple other related issues that we think many employers have been dealing with.
Thanks, Bill. That was great. So now we want to get into some specific issues that we know you're already dealing with. You've been working closely with NYSAC regarding a lot of these issues as well. So there's about 3 slides here, and we'll go through some of these topics, and then you might subsequently have some questions regarding this as well, these issues. So the big one is sending employees home who are sick, excluding employees from work, requiring employees to work from home, and then subsequently returning employees to work. So I'll start with sort of the first 2, sending employees home from work and excluding employees from work. This has been a hot topic, as I mentioned, and we are able to send employees home from work if they are symptomatic. There may be other, related to upper respiratory type that are related to the COVID-19 virus. And we certainly do not want to have employees who are sick with those symptoms in the workplace, particularly if they've traveled recently to a location with community spread, things of that nature, which is becoming all communities at this point. So we are able to send employees home. Always look at your labor agreements, probably not so much in employee handbooks, but there are labor provisions in some contracts that have certain procedures in place for sending employees home. If those procedures are dangerous at this point in time, I think the collective thinking is we will just not follow those procedures and deal with any grievance or action that comes later, because we do want to immediately, get the employee away from other employees. We do want to talk to the employee about what's going on safely, have the employee separated, make sure that you have protection, that the employee is protected, and get the employee out of the workplace as quickly as you can, but keeping in mind general disability discrimination rules, that we're not doing anything that creates a target on the employee. That brings me to an issue of communications. It's really important right now to communicate to employees. So if employees see that, or if that information spreads, we're going to want to make sure that we carefully communicate to employees and teach them that we're not discriminating against or retaliating against people that have symptoms. Not all people that have upper respiratory symptoms have the virus, and then certainly even if they do, that we have to treat people in accordance with the disability statutes. So that is very important to keep in mind. One thing that we're working on right now with a lot of municipalities is having a supervisor plain language guide for when may the supervisor send an employee home. So we've seen a lot of issues related to law enforcement around this, in that you've got some sergeants or people that are pretty close to the front lines making decisions to send people home, not send people home. Sometimes it depends on who the person is. Sometimes it's depending on if it's male, female. Sometimes it's depending on what color of skin the person has. So we need to really get training to those super busy folks right now that are the frontline supervisors. Some of us are putting into place procedures where frontline supervisors really aren't allowed to make these decisions on their own, that there has to go through some type of process, either through human resources or through the law department, to make decisions about who can be sent home, not sent home. Some counties are coming up with clear plans that are related to CDC guidance for non-healthcare workers, non-healthcare professionals, or even using the higher standards for healthcare professionals for levels of risk. Only sending people home if they fall into the CDC's high risk or medium risk categories, educating people regarding those risks, because another issue that we've been dealing with is employees who want to go home and therefore are saying things or making comments to other employees that are either frightening other employees or giving employees concern, or supervisors just sending them home because they said, my wife works in a hospital and there were COVID patients in the hospital last night. And so therefore then the decision is made to send the person home. Well, we don't really understand if that's a high level, medium level risk. Should we really be sending that person home? In this day and age, when we need essential workers to be at work, we really need to be careful about executing on those policies. So we really like the idea of creating clear guidance for supervisors that also ties back to these 3 laws that Bill and I just talked about, particularly the 2 leave laws, that the supervisor's decisions and whether they pay people or not pay people are rooted back to the state law and to probably more frequently the 6 reasons why a person may be out on the COVID leave under the federal legislation. So that's something that you want to think about. And it doesn't help to just hand out the posters of these laws because they're hard for people to understand. It's really, I think, important to create a policy and procedures where it's explanatory, such as when may a supervisor send somebody home? And then it lists out the reasons when a supervisor may send somebody home. Like I said, I like the ones that tend to be tied to the CDC risk levels because they're clear and understandable. Okay, so now, you know, bringing employees back to work after their leave. So let's say somebody's quarantined, that maybe they're utilizing the 14 paid days leave. We're returning them back to work. We want to make sure that we're following all of our normal process and maybe even more to our normal process to make sure that that person is safe to return to the workplace. So that is another thing to keep in mind. You have all those processes in place. Communicating to employees. So Bill and I have been working on a standard letter that you can use when an employee is removed from work that can help with the return to work. So that letter would go to anybody that was in close contact with the employee who now, let's say the employee is diagnosed as positive COVID-19. What do we communicate to employees? We have to be careful not to specifically identify people, but we can have a standard letter that explains the situation, what protocols the county has put in place to protect other workers and make sure that the workers understand that they are safe and there's no need for them to stay home, unless of course there is, and those are also part of our procedures of determining who should be sent home from work based on a COVID exposure, and that usually tends to fall again to the CDC guidance on levels of exposure. That brings me to the second bullet on this slide, the refusals to work. So we have seen some situations where employees are refusing to work. So I do want to be clear on this. Employees are only entitled legally to refuse to work in very limited circumstances. So under the PESH standards, which really flow from the OSHA federal standards, there has to be an imminent danger, and it gets very specific. It actually has to be like a situation that can cause immediate harm, physical harm, or death. So some people might feel that, okay, I was around this person, they were around a person that's been diagnosed for COVID-19, that puts me in imminent danger, that is a possible death. No, not based on the seats. That's again why having some clear guidance about risk levels to employees can really be beneficial. That's not a situation that an employee can refuse to work. Under our basic labor principles, the standard is work now, grieve later. So they really need to work unless and follow the instructions of the department unless there is this imminent danger, which is a very high life-threatening type standard. Okay, so that brings me to the third bullet on this, and there's been a lot of questions about layoffs, about furloughs, about terminations. Now we're seeing layoffs much more in the private sector right now, and that's always the case. It will happen there first, and then we'll move into dealing with public sector layoffs and the issue of layoff versus furlough. And so just so that everybody understands, the furlough is a situation where the person is not terminated, but their hours are going to be reduced. Layoff is a much more permanent situation, although with a layoff, there's usually an expectation or a possibility that the person could return to work versus a termination. We typically call these situations layoffs in the public sector when we're letting a group of people go for economic reasons. So it typically comes down to furlough versus layoff, and there's really no right or wrong answer here. You should look for sure in your collective bargaining agreements. A lot of our CBAs do in fact have furlough provisions that detail when and how a furlough may be employed. So maybe there's a limitation that you can only reduce to 32 hours. That tends to be the case with those furlough provisions because most unions have not wanted to drop below 30 hours for purposes of healthcare. They want to be able to maintain their healthcare in accordance with the Affordable Care Act or collective bargaining provisions. So usually there's some hours rules regarding furlough in your collective bargaining agreement. Sometimes there's just prohibitions on furlough, and that will put you more in a position of layoff. Some unions, depending on your relationship with unions, would like a furlough versus a layoff because it allows people to remain employed for the period of time if you really believe it's a temporary situation, and they can still continue to participate in the pension if it's people that still are needing to vest and things of that nature. So sometimes furlough is a more desirable situation. Sometimes unions would just prefer a layoff. In the last huge economic downturn, there was you probably recall, a major litigation where CSEA and PEF joined against the state with respect to the furlough legislation. So that was very undesirable at the time. And some in those cases preferred a layoff situation. So I just wanted to explain that and thinking about and having conversations with the unions regarding the impacts of that on the pension, the impacts of that on unemployment. Typically people that are furloughed only in part, won't be eligible for the unemployment benefits. So these are all things to keep in mind. With that too is the access of your retirement plans. So making sure that you've got all the forms and documents, because now more than ever, maybe not so much yet because people are all continuing to be paid, but as you move into layoff or furlough situation based on the state's budget and what's happens with county finances, you might be having more activity around the access to the retirement plans and pensions. So that's something to keep in mind and make sure you have all of those rules in order. If people are laid off and they've taken withdrawals from your different hosted sponsored plans unrelated to the state plan, that are you able to administer those types of payments back? How will you collect those monies? All of those are the things that hopefully your Human Resources Department is beginning to think about as they plan for the future after the initial emergency. On the next bullet, grievance filing deadlines. This is something that's a hot topic in labor right now. Some, but not all unions across the state have sent out mailings to the Human Resources Department with a signature block that says that the county agrees to hold on all grievance filings for a 30-day or a 60-day, or one I saw a 90-day time period. So they're asking for the Human Resources or the Labor Relations Manager to sign off on this tolling of the statute of limitations and your grievance procedures, your grievance filing deadlines. This is something that I'd be very cautious about. I think that some cases are very date specific. So maybe something had started and you were waiting for the process to work through, and extending the case by 60 to 90 days can create a bigger liability for the county. So we're really looking at advising on a case-by-case decision regarding that, but I suppose your situation might be that what types of issues are out there and you're more comfortable just putting the grievance filings off for 60, 90 days. But I just did want to alert you that the CSEA in particular is sending around a notice that they're looking for signature on. And remember, with joint employment situations with sheriff's offices, that might not be something that the county labor relations manager really can or agree to without the joint employer being involved in that decision making. And we're seeing a lot of issues there with respect to decisions in sheriff's office versus labor relations, and continuing the need to work together as joint employers so that our agreements are binding upon the other. In terms of filing deadlines and things of that nature, there's been questions about continuing to hold Section 72 or even just the physical screenings required for Section 72. Are we going to be able to get our employees to doctors for their physical reviews with respect to any open cases that we have going? A lot of doctors are continuing to perform those services for employees. So if you can continue to process those cases, you should. There's been some that have been done through health already, if that's a case that we want to try to process quickly within a 30-day time period. And whether or not you'll hold the 73 or 75 hearings is an issue that you should be looking at and making decisions. I think counties are doing different things depending on the circumstance of the case. We've run into some issues of non-exempt employees and telecommuting issues. So we've been so careful for years about making sure that our non-exempt employees are not working when they're not in the workplace, and that if they're texting or using emails, that that time is being documented so that we don't run afoul of the Fair Labor Standards Act. And so now with everybody working from home, it's a good time to remind people and send out a notice regarding appropriate timekeeping measures to make sure that there's not a situation where people either are doing things and not properly recording their time. So we've seen some missteps here in terms of we've got a big emergency happening. We're focused on other things, but we still need to continue to focus on the Fair Labor Standards Act and making sure that we've reissued policy and reminders about appropriate timekeeping for telecommuters. And the last bullet on this page kind of ties to that, what I was just talking about with the telecommuting. Have decisions been made in your county about handling expenses for employees who are working from home? And what is the process for that? What types of expenses will be covered? What won't be covered? We've had some employees putting in requests for, percentages of their internet provider, things of that nature. So you need to start looking at and be ready for those issues. Some of you that have not experienced initial claims by employees here might receive those once we get through the large part of this emergency. A lot of the labor matters have been on hold and pending, and then you can expect that once we get through the initial health emergency that you're going to start to see some issues here regarding telecommuting and expenses and so on. Next slide, please. Okay, so I touched on this a little bit on the last slide, but the disclosing of positive COVID-19 cases to coworkers. We have a standard template that we really recommend something like that be created for your county, where you have a special notice that goes to people who have been in contact with a coworker who is positive, and what precautions the county is putting in place, what the expectations for the employees should be. But there's some really good examples available regarding that type of disclosure. It is not an ordinary situation that we find ourselves in. We normally would not be disclosing confidential medical information to other employees, but in this case, it is a best practice to disclose as much information as possible so that employees can continue to be safe and healthy and feel comfortable coming into the workplace. There's been some talk that state laws might be passed to make workplace exposures to COVID-19 covered under workers' compensation under 207C. So there's no guidance on that yet, but it's just an issue we wanted to point out for identification as something that could be coming up as a possibility. And one big item that I know most of you are dealing with, and we've already talked about some cases related to this with Pat and with Steve, is the measuring of the body temperature. So this is happening in a lot of different workplaces where body temperature is being measured. It's never really happened before, and we have refrained from medical examinations, which this is, in the workplace. It's been prohibited under the Americans with Disabilities Act and the state human rights law in most cases. But the EEOC has developed guidance. It's actually a one-sheet guidance page, what you should know about the ADA, the Rehabilitation Act, and COVID-19. It's a good communication. It explains that the rules regarding medical examinations and the prohibition of employers conducting them without certain parameters in place have been lifted. For temperature taking, it's allowable, but we still need to be careful that we're following the specific guidance that the ADA has put in place. Having a policy regarding this is a very good idea so that supervisors or whoever's responsible for checking the employee body temperatures is following your rules that are in compliance with the EEOC guidance. The EEOC wants us to make sure that we're keeping the information as confidential as possible, that we're in no way maintaining that information, and that we're not discriminating against or retaliating against people that do have the elevated body temperature when they're coming into the workplace. So there are precautions we need to put in place to make sure that that is confidential. And then we fall back to sending the employees home, or what about employees that won't go home if they have an elevated temperature? What about employees that refuse to have their temperature taken? So that brings me to a question of whether or not taking employees' temperature is a mandatory subject of bargaining. It probably is, but in these times, normally, but in these times of emergency, the collective thought has been that this is something that we have to do to protect everybody's health and safety, and so it's a rule that the counties are putting in place, and then we could meet with the unions later about the impact of that. Some unions right now are demanding to talk about the body temperature, but I think most municipalities are relying on the emergency declarations to say this is something that we have to do at this time, but it can be a difficult issue. Most employees have actually appreciated the body temperature measurements, but if you, depending on the relationship with the union, you might want to think about how you're approaching those scenarios. But in any event, I wanted to make it clear that there are some parameters that the EEOC has put in place, so develop a policy so that you're at least meeting those ADA standards for this type of disability-related inquiry and checking the temperature. Okay, so the next bullet is very similar in the sense that it's another one of those examples of employees feeling that their privacy is being infringed upon or their rights are being infringed upon, requiring employees to report personal travel. So some essential services like law enforcement have really been concerned about employees continuing with their travel arrangements that they have in place. Right now, obviously, some travel is just impossible because of the rules regarding restricted flights and so on, or restricted travel to different countries. But there's still some employees that are wanting to drive down to Florida or do different things or continue to go to a conference somewhere that we might not want them to be going to. So whether or not we can require employees to report travel, again, in an ordinary circumstance is not something that we would do. It's certainly something we would negotiate in an ordinary circumstance, but we have to begin to think about, we might start having sick essential personnel, particularly if we're talking about 911 communicators, law enforcement, and other people that we really need available to do their jobs right now. And so some restrictions on personal travel have been put in place. I think counties are trying to do as little as they can, but at the same time protect other people. And so some counties have been thinking about, if you do, like let's say a sheriff's office issues an order restricting travel or putting in place protocol for advising the sheriff's office regarding the travel. What do you do if an employee disobeys that? Will you discipline them? That surely will be a situation that ends up probably in a grievance or some type of improper practice charge. Or do you allow them to go, but they aren't able to use any of their accruals? Again, something that's probably subject to negotiation, so you want to be very cautious about how you approach that. So far, we haven't seen too many problems in that area, not as much as we have with the body temperature, but it is something to be cautious about if different departments are drafting those types of rules. Now, if we do get into a layoff situation, thinking about, will healthcare continue to be provided? Certainly during a furlough, healthcare is expected to be provided in most cases, but in layoff, if they're truly temporary, will we continue to provide health insurance coverage? One thing I wanted to mention as we're talking about this. Older workers. So workers age 70 and over, what are we doing about those workers? We have some supervisors that understand the law to be that we need to send those people home, the law of the land in New York, that those people can't be in the workplace, but that isn't the law. In fact, the law is the opposite. We can't make employment decisions based on somebody's age at all. So we need to not be approaching directly older workers or removing older workers from the workplace. And I'm saying 70 plus because that's sort of the CDC guidance and what the governor has issued in terms of keeping older citizens safe. But we, as employers, we have to be very careful that we're not selecting older workers for removal. One way, as a best practice that employers have been approaching that, if you're limiting services of certain individuals, or if you're cutting back on different services that are being provided, you could look out for volunteers, and then maybe those older workers and similar people with underlying health conditions might come forward versus directly approaching people who are older or people with disabilities to remove them from the workforce. Those cases can certainly be problematic later in terms of ADA and human rights claims. To think about there is also whistleblower issues. So if employees are coming forward with safety concerns or safety issues related to COVID-19, all of your individual county policies that you have in place for whistleblowing will be in effect. If you have ethics offices that are taking these complaints, it's a good time to remind people of their opportunity if they have a concern about something that's going on. Some people begin to act lax when the rules are relaxed or different in the ways that they are today. So maybe some people, there's theft of time or services that are going on. All of those things still should be brought forward either through your ethics hotline, your whistleblower hotline, whatever you have in place for those issues. But the ones I'm thinking about mostly are workers that are concerned about their health and welfare because maybe the right personal protective equipment isn't being used. Make sure that employees know how to make those types of pieces of equipment available and how they can bring forward any concerns that they have right now about health and safety. The next slide. Just a last few issues that we wanted to cover with you on some hot topics that have been coming up. And that the big one has been hazard pay. Should we pay time and a half? Should we pay essential workers or certain essential workers more? And this is happening both in the public and private sector. So there's no right or wrong answer here. Some employers are utilizing hazard pay, some aren't. But we have to look at the entire scope of the situation. Frankly, a lot of counties have hazard pay type provisions in their contract. Some employees have emergency pay provisions in their collective bargaining agreements. So just because somebody's doing that doesn't necessarily mean that they're doing it you know, just now because of COVID-19. There might be some prior emergency pay grievances or arbitration decisions that they're dealing with, MOAs. I think it is a good idea to kind of look at the locality and make sure that, you know, you're staying as much, you know, on the same page as you possibly can with surrounding counties. But remember that all of us have different facts and circumstances that we're dealing with on paying people time and a half or hazard pay. And just because one county has it doesn't mean that another county should have it. There could be a lot of underlying reasons why that's happening. And some people have criticized it. Some people have said it's a good thing. So there's no clear answer on that, but it's something you have to be aware of and thinking about and not sort of having that type of issue catch you by surprise. Certainly checking the CBAs for any emergency or hazard pay is important because you don't want to be accruing liabilities just because the union hasn't filed a grievance or you've signed off on something saying we're tolling grievances for 60 to 90 days and meanwhile you were supposed to be paying time and a half per the CBA provisions. So very important to keep in mind. And then another hot topic has been, can we require people, whether they're working from home or not working from home, to be doing duties that they would not have ordinarily done? This is happening all over the state and frankly all over the country, that workers are working outside of the scope of their job. Most CBAs have an out-of-title work provision that has a certain process in place before an employee may work out of title. Make sure that you're still following those procedures unless it's really not practical for those procedures to be followed. One thing that I am seeing happening quite a bit is that employers are saying, well, because of the declaration of emergency, we don't have to do XYZ. We really, if to the extent we are able to follow normal process, we need to follow normal process and really should only be making exceptions where the emergency does not allow us to act in accordance with our normal process and procedure. So I think we have to be careful about working out of title and making sure that we're not just being too relaxed because of the emergency and that we're following all of our appropriate procedures. If employees work out of title for too long of a time period, of course, there can be claims that are made under the civil service law as well. So we do want to try to keep supervisors on as much track as possible. And if they have a need for an employee to perform a function that they don't normally perform, make sure that the supervisors and managers understand that they need to get approval through Human Resources Department, could be the Civil Service Commission or county law. We did have some questions in advance about what about employees that are on sick leave before this outbreak. If they were already on sick leave, there's really, and it's pursuant to a doctor's requirement that they're out, or they're already on FMLA. That's not something that we have to go back on unless we get to a point where we do not have enough staff and we need workers, and maybe at that point in time we're looking back to those employees to see if there's any way that they're able to return to work, even in some limited capacity. Maybe we didn't have light duty work for certain individuals at one point in time, but now as an exception we want to create a policy where we're bringing people back, or even retired individuals back, to help out with this sort of all hands on deck situation. So that's you know, the main thing is that our ordinary disability rules and FMLA rules are going to apply to those situations. We already covered temperature taking. I guess that was so important I wanted it on there twice. And then accrual use, I think Bill and I covered that in terms of the new laws are pretty clear that they're on top of existing accruals, so you won't be having employees use accruals if they're related to the 6 reasons in the federal law, or of course the quarantine situation, which is covered by both the state and the federal leave law. But should you be allowing people to use accruals? Most of you know by now that employees are losing accruals if they are not able to take them right now, especially if they're non-essential, they're working from home. The state did put together an agreement with its CSEA, its large CSEA union, which allows some rollover of the earned vacation days not to be lost, and if the anniversary date is hitting during this time period. So the state did negotiate an agreement. I think that's important from the perspective that something I mentioned just a moment ago, that some of us are thinking, well, because it's an emergency, we don't need to negotiate. That's not true. If we're able to negotiate on an item, we still have the responsibility to negotiate on an item with the union, particularly something with accrual use and vacation days. And frankly, the fact that the states the GOR was able to negotiate this is an indication that we probably all have time to enter into those such agreements. It's a simple agreement. If you don't have a copy of it, we can certainly provide a copy of it, but employees are looking for some type of guidance regarding if they're going to completely lose their accruals. We have to be careful here in terms of we don't know what financial times lie ahead for us. So are we really able to roll vacation into another anniversary year for the employee? So all important things to think about, but I do think those are things that are mandatory subjects of negotiation that is not impractical to try to negotiate around those, particularly if somebody from Human Resources can work on that as a project. And then we talked about employees a little bit with pre-scheduled vacations. That's a decision point that every county will have to make in terms of, are you going to allow people to continue to take those if they're working from home? Are you going to allow, I think that you need to create a process and have some protocols in place so that different departments aren't necessarily doing different things, or at least that we're being consistent with respect to these decisions so that we don't have discriminatory decisions being made by different managers, supervisors. Those were sort of the hot topics that we could think of. I'm sure a lot of you have questions as well, but we did want to just bring up some of those issues that we know have been surfacing repeatedly already. That's what we had covered. So if you have questions, we can go ahead and start taking those.
Karlee, Bill, Pat Cummings again, thank you so much for this education. We truly appreciate it. We've got some already typed in a number of questions. I'm going to be mindful of time. We're already, I know we said this would be an hour. It's such a large topic that we're a little bit over. I'm going to try to hit some of these questions with you quickly, and those that we don't get to, we promise to, we'll get them to Bill and Karlee and get them back to you either directly and or both over the coronavirus at NYSAC.org. And if you have a question that you didn't type in that you think of even an hour, 2 hours, next day later, send that in to us and we'll get you back the answers as best we can and as fast as we can. The first question, I think, Karlee, you went over dealing with the different forms for sick leave that For a child, there's a different form. If your child's quarantined, there's a different sick leave form, and that qualifies. Question is on that. Is a child defined by age within that either form or law? And if so, what is the age to qualify?
Yes, that's a great question. It's 18. So 18, under 18 is the rule for the state law. The other, so that's very clear. The other issue I wanted to mention is that on the federal side, we are expecting like some type of revised FMLA forms with respect to the emergency FMLA. If not, it might just be your standard FMLA forms. And this is a good time to, if you've got folks from Human Resources working at home, assign somebody to be reviewing your FMLA policies and packets to make sure you're using updated forms. Sometimes I see outdated forms still being used. So for now, using the current FMLA forms that are available on the USDOL website, and waiting to look for the guidance, which we're expecting this week or early next week on updated forms.
Thank you. And then the next question, and I know you just touched on accruals. We have a specific question dealing with those that are directed into quarantine or isolation. And I think it's probably in two different categories. If one's directed by public health, with their local health, public health, and then in a scenario where one is only directed by their doctor to be in isolation as opposed to the public health official, in either case, can a county charge accruals in your opinion?
Probably not, because the first situation, the quarantine by the local health department, so that's the governmental quarantine, that's definitely going to be covered by the 14-day New York State rule, right? Because that's a very specific benefit for that the governmental directed quarantine. The self-quarantine is obviously trickier, but when Bill reviewed the 6 categories for the federal leave benefit, I think that that physician's direction on the quarantine is going to fall into a couple of those different reasons why somebody can use the federal benefit. However, I will say that we have to have some controls put in place regarding that, because we all know that doctors, right? Hopefully not now. Hopefully there'll be some sensitivity to needing workers in place, but our past experience has been that doctors will write the notes that their patients want them to write. And so we want to be careful about this. I mentioned earlier the CDC standards. So particularly in law enforcement, we see different sheriff's office putting in place rules of when is a self-directed quarantine, and by self-directed quarantine, we should define that to include these quarantines that are issued by doctors, individual doctors, and when are they appropriate to have somebody be out of the workplace. So putting in a process that we examine that situation and have some criteria and standards in place so we don't have everybody being written out of work. Now more than ever, we were significantly reduced, right? We're under 50% staff, and our essential folks are being exposed. And so we need everybody to be kind of all hands on deck. So I would recommend some policy and procedure for each county to put in place regarding how those doctors' notes for self-quarantine are going to be reviewed.
Thank you so much.
If I could just briefly add, that would definitely cover the second of the 6 grounds under the federal emergency paid sick leave. And that third one is one that should really be given attention, because that is just where the individual is experiencing symptoms and speaking. So as Karlee mentioned, in the past, we had doctors maybe issuing notes, kind of a blanket note to employees. That third one introduces a whole new area of potential gray area, where someone can say they're experiencing symptoms and then maybe could just simply say, and I've reached out to my doctor and I'm waiting further information. So just 2 kind of important pieces to think about with respect to just the federal ones alone.
Okay, I'm going to combine 2 questions into one, and then I do see there's a number of other questions. I'm going to ask this one, and then we'll follow up with the rest. I promise. And then on top of that, any other questions that come forward, again, we'll address those as they come in. this question's it's kind of a two-parter dealing with FMLA leave, expansion thereof. The question is dealing with what qualifies as a day within the 30 days as far as hours worked. Is it any time at all during that 24 hours? What takes to qualify as a day with the 30 days? And then on top of that, do those days need to be continuous, or can that be scattered to qualify?
That is a great question, and one that I expect we're going to see some further guidance on for sure. There has been some discussion that it doesn't necessarily need to be consecutive. So if you have someone who is a long-term employee, but it's been sporadic, or not a long-term employee, but an employee who's been employed in maybe a couple different segments, it could be a cumulative 30 days from a longer period of on and off employment. Again, this is an area that I do expect we are going to see some clarification around to help out with some of these one-off scenarios.
And thank you. And I said I was going to cut off there, but I just saw one come in that I've gotten this from a few other people that I really think is important that we get clarification on, or at least some guidance on. And that is, especially as this virus keeps spreading and getting to more and more counties upstate, we talked about this, that we've got the right, or maybe even duty, to disclose fellow employees that have got a positive COVID-19 test. Can you expand upon that a little bit? And then on top of that, is that's just limited to COVID-19, right? It's not any other flu, any other symptoms that we know that one's been experiencing. And then on top of that, is this a limited degree of disclosure? What are we disclosing to employees? Is it just the immediate office they're working to? Do you tell the whole county? What's best practices there when we find out an employee has unfortunately tested positive?
So when I mentioned the disclosure, there's most counties are putting in place like a standard communication that goes out to employees regarding this. Best practice is keeping that disclosure as limited as possible. We're certainly not identifying people by name. And yes, Patrick, that's exactly right. We are not doing this for any other condition. This is a positive COVID-19 case. So this is somebody that's been tested, they're positive for COVID-19. We know that they've been in close proximity to other workers. And so in those instances is where we're recommending an employee communication occur. So that definitely wouldn't be countywide. And frankly, we're starting to have so many more cases that countywide, is probably not at all practical. And I think it just causes people more concern and confusion. So we're trying to limit that concern and confusion, but at the same time, making sure that we're informing the people that, we're in contact with the employee who tested positive, that they're aware of the situation. And if we believe that certain individuals, due to the exposure, should also not be in the workplace, that's something that we typically would also communicate in person to person.
Well, we thank you so much.
I think a lot of employers,
I'm sorry, Bill?
Oh, I was just going to say, in a lot of cases, folks are using that as an opportunity to also remind employers of, or remind employees that, look, if you're developing symptoms, please don't come to work. So it's almost a reminder that, look, we have had one case where someone in the workplace, and just as another reminder, if you are feeling ill, you're having flu-like symptoms, please do not come into work. Notify your supervisor that you're having symptoms. So again, just getting it out there in front of these folks again, that please communicate if you do feel like you are having symptoms.
Bill, Karlee, on behalf of NYSAC and the counties we work for, we thank you for this information. County members, please know that we will be making these slides available to you all shortly. And so please feel free to distribute these. And if you need to reach out to Karlee or Bill, their contact information is on the first slide. So thank you again for joining us, and thanks again to Karlee and Bill for this information.
Great, thank you, and best wishes, everybody.